Dr. Coetzee, we can start.
Thank you so much. Good evening to everyone. And thank you for attending this meeting with us tonight. This is going to be a very interesting meeting. My name is Dr. Angelique Coetzee. I'm the chairperson of SAMA, and it's my pleasure to welcome you all to our webinar today. These webinars are extremely popular because we are touching on important specialists on those topics to address us, which adds immense value to the discussions we are having. To ensure we all adhere to the correct etiquette of this webinar, I would like you to request to please switch off your cameras. Please mute your microphones if you are not speaking. And there will be time after the presentations for a question and answer session. So I'd like to request you all to keep your questions for this time slot going forward. Today, our focus is on medical scheme clawbacks and on Section 59 litigation. As we mentioned in the invitation to the webinar, SAMA has been in discussions with a legal firm representing a large number of concerned practitioners, and this webinar is intended for all affected. SAMA members, where the various processes and details surrounding the possible legal challenges will also be outlined tonight. So our first speaker tonight is Prof. Bridget Kuschke. Without going through Prof. Kuschke's extensive resume, let me highlight some key points relevant for tonight. Prof. Kuschke is a practicing attorney, notary, and conveyancer. She graduated with a degree BLC cum laude in 1986 and LLB cum laude in 1988 from the University of Pretoria. In 2009, Prof. Kuschke obtained an LLD degree at the University of South Africa for her thesis entitled Insurance Against Damage Caused by Pollution. Prof. Kuschke holds a C2 NRF rating as a researcher. Prof. Kuschke is currently an associate professor in the Department of Mercantile Law and the director of the Unit for Insurance Law and Governance at the University of Pretoria. Her areas of specialization are insurance law, engineering, and construction law, general law of contract, law of delegate, and legal and commercial aspects relating to project management. Bridget has authorized and co-authored several articles and reports and has presented at several local and international forums. It is my honor to invite Prof. Kuschke to address you now. Thank you. Over to you, Prof.
Thank you very much, Dr. Coetzee. Good evening, colleagues and all the attendees. I am very thankful for the opportunity that we have to address you tonight, especially in view of an escalation that we have seen in view of the practices and malpractices within the medical schemes industry, if I may call it that. My aim tonight is to inform you as to the Section 59 clawbacks that are currently, as I mentioned, increasing, and also to provide some background as to why Section 59 is in the Medical Schemes Act, and then also how it at the moment is being interpreted by medical schemes, where pending litigation is standing at the moment, and then to ask for questions from the audience for any questions that you might have directly from your membership to both me and my colleague, Professor Willem Gravett. Professor Gravett will be assisting us with the burden of proof discussions and the law of evidence. He's a professor in the law of evidence in the Department of Procedural Law at the University of Pretoria, a very good colleague of mine, and also he's practicing at the New York State Bar. So Professor Gravett, I think, is optimally suited to assist us in this specific discussion. I will, as a lecturer, obviously first briefly sketch the reasons why the Section 59 section has been introduced. And then I think from the diagrams that I've included, it will become clear why the legislation is where it is and how it can be abused or misinterpreted, as is very often the case in some of the situations that we have been confronted with. On a brief personal note, I became involved in the Section 59.3 issues because my own physiotherapists approached me when they were approached for a meeting on coding, which turned out to be incredibly aggressive. I agreed to represent them. And from then onwards, it picked up steam in the sense that it became quite clear that there is a long history of Section 59.3 not being optimally interpreted for medical practitioners, and as I say, currently open for abuse by the medical schemes or funds. So the act we are talking about tonight is the Medical Schemes Act. I will refer to it from now as the MSA. And we will talk about schemes and not funds, although this includes any of the medical funds and schemes that we all know as medical aids. So my very first slide, I just need to get in here. There we go. Apologies. It's just hanging for a while. Is just then the introduction, the brief overview of the legal principles, then the purpose of 59, the abuse of it, and then the merit of the current cases. There is one case pending at the moment in the High Court in Pretoria. There is another one soon to be instituted, and then we are aware of individual claims that have been brought by individual practitioners elsewhere in the country, all of which I will be referring to. So the first point that we need to discuss today is the legal obligation. And legal obligation means the legal connection or legal tie that exists between persons. And this is important for us because it all boils down to how a medical aid is connected to the individual practitioner, and then how the Act attempts to overcome some of the complications caused by the absence of a direct obligation, and how this is then in practice dealt with. So just briefly, in law, you cannot have rights or duties unless there is a reason for the existence of the specific rights and duties. And for that, we need a source of legal obligation. And I've listed the basic 6 sources for you there. The first, obviously, the strongest is where parties choose to be legally connected to each other, where they have an obligation towards each other. And that we call, obviously, the contract, and that is concluded via free will. Some doctors do have contracts with medical schemes, others do not. The second one is delict or wrongful conduct. This you will also know as where a doctor is acting wrongfully, negligently, or intentionally, that creates a potential delictual claim for damages to be instituted by patients or families of patients. The third one is unjustified enrichment. Very important to note the 2 words and not just the word enrichment. Unjustified enrichment means where one person is enriched at the expense of another without reason thereto. And that is where the whole imbalance between contract and enrichment comes in, which we'll have a look at a little later. So the words unjustified enrichment mean that without legal cause, one party is impoverished and the other one is enriched, and then the law recognizes an enrichment claim. The fourth is unauthorized agency, where one represents another person to his or her best benefit. That does come into play where you as practitioner represent your patient and where the medical aid represents their members in the triangle of relationships that will exist, and that's what I will indicate in my next slide. Then, of course, we have legislation, which we refer to as an overarching term statute, which creates legal obligations or connections between persons. And that is what the MSA aims to do, to create a legal obligation directly between practitioners and schemes for purposes of enrichment claims. So that is, in a nutshell, what Section 59 is about. And that is why I've put these keywords up for you. And lastly, family relationships. That's the last source of legal obligations generally accepted. If you ever wondered why you have to still support your children, even though they might appear to be grown up, that's the reason why it has to be. So before we continue with the Act and the exact wording of the section and then the interpretation thereof, I need to discuss with you the structure of set-off of debts, because this is what a clawback is, in essence. That is where a medical scheme alleges that an amount is due to it because of an overpayment, incorrect coding, or improper claim, and that in exchange for getting that money back, they are entitled to set off new debts that are owing for your new patients, for other accounts, other claims that you have submitted. So just very briefly, a set-off of debts in terms of contract is where X owes Z 50, Z owes X 40, and therefore the law will automatically acknowledge that only the outstanding balance remains payable. Set-off, therefore, is something that happens automatically. However, there are some requirements, and the first being the debts have to be of the same nature. So I cannot deliver services that I cannot prove an amount of money in its value against an amount of money. I need to be able to set off debts of the same nature. I owe you, you owe me, and these must be capable of set off. Then, of course, the debts must be due and payable. That is one of the points that are one of the points that is not adhered to at the moment by the schemes, that they do not prove that the debts are due and payable to them before they just allege and claim a set-off. Then liquidated debts means that the debt must be able to be conveyed in an amount of money, in a specific rand and cent value. It has to be a certain amount. Again, many of the clawbacks are lacking in meeting that third requirement. And then debts must be between persons in the same capacities. And that is where we have our section 59 trying to bring a triangle of relationships into the requirements of a valid set-off of debts. So debts of the same nature, they're both financial, the money withheld by the scheme and the money that the scheme alleges the practitioner owes them. Due and payable, that's a questionable requirement. Liquidated debts, that's a questionable requirement. And debts between persons in the same capacities, that cannot exist purely because of the allegations set by the specific medical schemes. So here's a brief schematic diagram just to indicate where the gap lies. The patient, of course, is the central party to the entire relationship, a contractual claim with its medical scheme or medical aid fund, and then it has a contractual claim with the practitioner whom it has seen for medical treatment. However, the gap lies between the practitioner and the scheme. Some of the practitioners do have contracts with some of the medical aid schemes, but not all of you do. Contracted in, contracted out, those are the general terms that we hear. And the clawbacks, in a case where there is no express agreement between a scheme and a service provider or practitioner, those are the ones that create the most chaos at the moment because of a lack of clarity. Bringing it just back to this slide, here you will see the patient still being the central common ground here, contractually bound to the scheme, practitioner bound to the patient, and then, of course, an express agreement for a contracted in scenario. And that agreement will regulate when and how a scheme may directly claim from a practitioner, may withhold money from the practitioner, and in other words, therefore, enforce a set-off of debts for an alleged enrichment claim. So where you do have a contract with a medical scheme, the exact wording of that contract will be of the utmost importance for your lawyers, for your attorneys, to interpret exactly what your relationship is with the various medical aid schemes. It is, however, for the majority of practitioners, not the case that they do have a direct contract with the schemes. And this is the slide that indicates now where and why Section 59.3 has been introduced. So again, common ground patient, contractually bound to the practitioner, contractually bound to the scheme. However, practitioner and scheme have no contractual relationship with each other. And that is what the Medical Schemes Act has attempted to bridge. The reason is that if a scheme would, on behalf of a patient or its member, pay an amount that is undue to a practitioner, claiming it in a court of law, suing for it, would be nearly impossible because it would be for a very low amount. Legal costs are rising, they are extremely high, and therefore the government, the Council of Medical Schemes, decided that they would create a statutory right between the scheme and the practitioner to create a direct legal obligation to allow for a claim. This claim will be for enrichment, the unjustified enrichment that we mentioned earlier. And this claim will be extraordinary because it is not founded on the basic principles of the law of obligations. It is not founded on express contract between the practitioner and the scheme. And therefore, it is an extraordinary step that was taken to try and give the scheme a right to recuperate money directly from a practitioner for improper coding or improper claims. As an extraordinary measure, the legislation will only intervene if there are strict requirements set and met in order to create this extraordinary legal obligation between the scheme directly and the practitioner. And therefore, the wording of this section is extremely important. The interpretation thereof is of great importance. It is an extraordinary measure, and that is what the schemes are misunderstanding. They see it as a general free-for-all, let's run into the shooting range and claim from anybody, withhold money whenever we feel like it, because the section says we may do so. The section is heavily qualified and, as an extraordinary measure, must adhere strictly to those requirements. I've added the wording to the slides. I find it's always easier for persons to see them rather than just listen to them. The first two subsections of Section 59 are not of great value for today's discussion, but it is just for sake of a comprehensive reflection of Section 59 that I include them here. And this is the first one, the duty to provide, of course, statements of accounts, and that is regarding their members. And then furthermore, the 30-day payment period within which a medical aid scheme must respond upon the request of its member to pay a specific practitioner to, in fact, reimburse that practitioner on behalf of the patient, of course. So always remembering the triangle of relationships. Now, preceding these two provisions, we of course have Regulation 6. And Regulation 6 is what has to happen prior to any scheme being entitled to continue further down the line with Section 59 and invoke the set-off allowed in terms of law for enrichment claims in terms of 59.3. So Regulation 6 states very clearly a medical fund has 30 days to query a claim from date of its submission. This gives the schemes sufficient time to raise concerns and to query, whereafter the practitioner has 60 days to rectify any errors. Only then, after that time, when there is still a dispute, then Section 59.3 kicks in. And this is where we have a long-standing disagreement with some of the medical schemes, specifically Discovery, in my case, where I have been at loggerheads with them. They allege that they have so many claims per day that they cannot meet the target set by Regulation 6, that they have 30 days in which they must query a claim. Now, that for me is nonsense. If you do not have enough staff, then you employ more. You reduce the size of the building you are in and the staff that you are employing for reasons other than the principal business of this specific medical scheme. So 30 days is sufficient time, especially where we have some pre-authorized claims. There's even a longer time period allowed for those. The practitioner has 60 days, within which he may then change his bill or statement of account, change the coding of the claims, etc. Now, after the 60 days, when the scheme is still not happy with the claim submitted to it, and it still in some way alleges irregularity thereof, it challenges its validity, then only Section 59 will come into play, 59.3 will come into play. But that is only if the claim has not yet prescribed. Now, what does prescription mean? Prescription is where the law allows you a shorter time period to claim for any claim that you might have, any right that you want to enforce, than to allow you to forevermore return to older claims. So I just quickly want to go to prescription. I just want to discuss the first two sentences there of the Prescription Act, and I'm going to return to the slide. But just the explanation of prescription. Prescription, in the case of your accounts, your claims that you have against schemes or funds, states that the fund has 3 years to claim for any outstanding amounts. The Prescription Act, Section 11D specifically says there's a prescription period of 3 years for any debt, unless otherwise provided by statute, and this includes claims based on contract, delict, and enrichment. And these are the claims that you will have against your funds or schemes of your patients. So before we get to the complication then of that, once a claim is not yet prescribed, it's not older than 3 years, it has not been paid, it has been rejected by the fund, Section 59.3 comes into play. Section 59.3, notwithstanding anything to the contrary contained in any other law, a medical scheme may, in the case of any amount which has been paid bona fide, that means in good faith, in accordance with the provisions of this Act, and that includes Regulation 6, to which a member or supplier of a health service is not entitled to, or any loss which has been sustained by the medical scheme through theft, fraud, negligence, or any misconduct comes to the notice of the medical scheme. The scheme may deduct such amount from any benefit payable to such a member or supplier of a health service. So 3A, we must look at the words paid bona fide. Now that means that in good faith, the medical scheme has paid, and in my view, that means the medical scheme has actually done its homework. It has complied with a 30-day period, and the 60-day period was allowed for amendments for incorrect claims, or the medical aid has continued to meet its obligations in terms of how it must run its business as a main insurer, as a medical fund. So where a medical aid pays out nilly-willy, just because it just wants to get rid of some of the claims on its books and comes back 4 years later, for me, that is not a bona fide payment. For me, that is not something that will comply with A. Challenging Section 59.3b is that only where a practitioner has committed theft, fraud, negligence, or misconduct, may the scheme then use the set-off. It means it may then withhold money that it owes a practitioner for other patients. And of course, that must be where the claim has not yet been prescribed. I would like to here just invite Professor Gravitt to address you regarding the words theft, fraud, negligence, or misconduct and the context within which they are used here.
Thank you, Professor Kushka. Good evening, everyone. The question surrounds the basic question: theft, fraud, negligence, or any misconduct according to whom? Because unless legislation specifically defines these terms, which the Medical Schemes Act does not do, we have to look at the common law to see what they mean. And fraud and theft are both common law crimes, which mean the state is required to prove each of the elements of these crimes beyond a reasonable doubt. Negligence and misconduct, negligence has a specific legal meaning also, and misconduct must also rise to a standard presumably set by the Health Professions Council. And negligence and misconduct must at least be proven on a balance of probabilities. Under no circumstances did the legislature intend for medical schemes to determine on their own when a medical practitioner has engaged in fraud, theft, negligence, and misconduct. If not a court in the case of fraud or theft, or by the Health Professions Council in the case of negligence and misconduct, there must be some independent third party who can determine whether a medical practitioner has engaged in fraud, theft, negligence, or misconduct. And that may be where the whole solution to the Section 59.3 mess lies. So moreover, in addition to the burden of proof that goes with each of these terms, theft, fraud, negligence, and misconduct, the medical practitioner must be afforded due process, the right to a fair hearing, which means the medical practitioner must have a fair opportunity to understand fully the bases upon which the medical scheme initiates clawbacks, meaning all the documents upon which the medical scheme relied in reaching its decision, and then an opportunity to respond to the medical scheme's claims. This is also a principle in administrative law, audi alteram partem, which means each side must have the opportunity to be heard for any administrative action to be legal. So it's my understanding that this is not currently happening. We've heard some horror stories about how practitioners are kept in the dark and then browbeaten and bullied into settlements with the medical scheme. I would also expect that if a medical scheme believes in good faith that a medical practitioner has engaged in fraud, theft, negligence, or misconduct, the scheme would open a criminal case against that practitioner at the police, or at a minimum, lodge a complaint against the practitioner at the Health Professions Council. And it is also my understanding that this has not occurred in a single case, which for me calls into question the good faith of the medical schemes who engage in these clawbacks.
Thank you very much, Professor Gravitt. So the underlined section of Section 59.3b is what at this moment in time is being challenged in the current case before the courts, which I will refer to a little later, and then the potential solution that the applicants have come up with that are not necessarily held by other litigants in the country. But just to remind you, we will be returning to those words. You might not be seeing them. Then I just need to wake this up again. Section 59.3, as we said, allows for a right to a direct claim via set-off only, where the claim lodged by the practitioner was due to that conduct. And we're talking about the set-off here, and that the claim had not yet prescribed. Now, we have heard stories, and these are not just stories or sub-stories, these are actual versions of practitioners who shared with us the absolute, they distraught, the absolute distress about the claims that are being made against them, the fact that funds are being withheld for long periods of time. We have had some claims being revisited as far as 7 years ago, practitioners who have now been told that they owe money from way back when, and therefore they will receive no new funding from the specific funds. Now, just to revisit, the Prescription Act is our general overarching act that determines periods of prescription. There are various ones, 3 being the least, and that is for the debts that we are discussing today. There are prescription periods of 6 years, and those are for prescription of claims, for example, vested due to a notarial document. Of course, claims against the government prescribe much sooner than the normal periods, whereas claims by the government might sometimes prescribe only after 30 years. For example, tax. So in the event that you owe tax, it's 30 years from now before you can breathe freely again. Now, the Medical Schemes Act mentions nothing about a specific prescription period for the set-off of these enrichment claims. The Act is silent on it. Very seldom do we see prescription periods beyond the Prescription Act itself. Here and there one might see it, but we are talking of a few cases to be counted on both hands for the last 100 years. So the Prescription Act, being the overarching act, is the default. The Medical Schemes Act, being silent on prescription, means automatically the Prescription Act applies. However, Discovery and other medical schemes allege that because the Medical Schemes Act says nothing about a prescription period, that they are not subject to prescription at all. Now, that cannot be, because other legislation, such as the Consumer Protection Act, the Conventional Penalties Act, the National Credit Act, these are all large bodies of legislation that regulate so many relationships. Those acts do not refer to specific prescription periods. Does that mean that prescription never applies in their cases either? And the answer is clearly a resounding no. If an act is silent and it does not mention a specific prescription period, then the Prescription Act applies, and the period is 3 years. So it is not acceptable for funds to claim back for payments that they claim are due for a period of longer than 3 years from date that it was payable back in terms of enrichment. So what are the actionable points? Firstly, the schemes do not respond within the time limits set in terms of Regulation 6. Regulation 6 states that this is what must happen. It is not a choice. A scheme that passes beyond that time is in trouble. It has 30 days within which it must manage its claims handling process. This is a principle in terms of insurance law. You need to follow proper claims handling. You cannot postpone claims indefinitely because there is a financial reliance by the other parties in the relationship upon the conduct of the medical scheme. And as I said, if you do not have resources, then you should deploy more. If you are going to declare bonuses at the end of a financial year to the extent that some of the funds have, then pleading poverty in order to meet Regulation 6 time periods is not an acceptable thing to do. The schemes resort to self-help through Section 59.3. By prematurely, without proving the practitioner's responsibility or liability. By prematurely just setting off debts, the schemes are resorting to self-help. And in our law, self-help does not carry weight. You cannot help yourself just in any way you wish to. There are legal remedies, and these legal remedies are there for very specific reasons. They are controlled, they are regulated, they are governed. You cannot just do as you please. With regards to some of these schemes, they allege that a certain coding was incorrect. Pausing briefly here, we all know that the coding guidelines are in many cases insufficient. We see a lot of situations where the activity-based practices have a problem in the codes that they allocated or identified for a specific procedure, where the schemes hold the opinion that it is an incorrect coding. And that needs some attention. If I may bring that to the attention of the Council of Medical Schemes, the Department of Health, that sooner or later, somebody needs to sit down and do something about this. The time-based activities, that is more clear, that you cannot see more than 12 patients a day if you are seeing them at 1.5 hours per day per patient. Those are all quite logical. However, with the activities-based, the codes are a bit unclear. So what is happening is some of the schemes are alleging that there's improper coding without providing proof, without a peer review, without, in many of the cases, not even providing a decent forensic audit to the practitioner or allowing the practitioner to engage in it. They already find the practitioner guilty of theft, fraud, negligence, malpractice, all 4 of those, and they decide set-off is the way to go, and they immediately start with the set-off. Regarding my own physiotherapists, we met on the Monday. We challenged a specific coding query, and from that Thursday, they did not receive a single cent from the medical scheme in question. Before there was even a discussion on the merits, before there was an opportunity to even respond to the allegations, there was one meeting, it was online, it was accusatory, it was incredibly traumatic, and on the Thursday, the tap was turned off, and that was the end of that. And that is what a clawback briefly is. That is how the schemes can abuse Section 59(3). And now we need to just quickly revisit the following. Are the amounts due and payable? As Professor Gravitt said, that requires proof. For theft and fraud, if the scheme alleges that there was theft or fraud at the side of the practitioner, it must be proven beyond reasonable doubt. So beyond reasonable doubt, it's a criminal burden of proof. And there are many accusations that are made towards medical practitioners that they are defrauding the scheme, that they are stealing from the scheme. These are express emails. These are statements made during meetings that are incredibly traumatic for medical practitioners. You cannot allege that somebody is defrauding or stealing unless you can prove that. As far as negligence and malpractice are concerned, we have the same situation there, that allegations are made of negligence. However, the burden of proof that on balance of probability you were negligent or you were guilty of malpractice, that is not provided. Are the amounts liquidated? Well, we've seen so many forensic audits. There are 2 reports, the Gilby report and the Morrison report. These were all procured by the Physiotherapist Society. And the forensic auditor in those reports attempted 3 different ways in which to calculate the amount that was allegedly due to a scheme, and could in no ways reach the total that the medical scheme had claimed it was entitled to. There are firms of forensic accountants that assist medical practitioners. I think you know Healthman, for example. They are not lawyers, they are not attorneys, they do not assist in cases. They do, however, assist in the peer reviews and in forensic audit panels. And those processes must be followed before a set-off can take place in terms of Section 59.3. There has to be a burden of proof that has to be met. And of course, on the conduct of the practitioner, peer reviews have to be done. Now, the history has shown the last year that some of the schemes bluntly refuse to accept any external panels, no matter how well they are put together. We've seen for physiotherapists, for example, that the head of the ethics lectures for physios at the University of Pretoria and senior physiotherapists, also intensive care physiotherapists with great experience, were put together on a panel, and those members then adjudicated on a few coding issues or matters. Their report was outright rejected by a medical scheme, and the medical scheme chose to do its own peer review. Its own peer review for physiotherapists consisted of a single chiropractor employed full-time by the medical scheme, who is not registered at the Health Professions Council of South Africa to practice as a chiropractor in South Africa. Now that is irregular. And these are the irregularities that I think people have realized they want to stop. And this is why there is momentum growing in the country to try and get clarity from the courts. We're not going to get it from the Council of Medical Schemes soon, unless they present us with a final Section 59.3 report, which is still outstanding, but to get clarity on how a medical practitioner can become liable to pay back money to a scheme, and then how a scheme then can try to recoup that by setting off amounts against payments due for new patients. And that is why we want to go to court. We need to see what must be done in due process and how this will lead to an eventual fraud management, which we support completely. I think everybody understands fraudulent claims should be found, should be held liable for, but you cannot just shoot into the bunch. You can't just decide to withhold monies from persons without following due process. What do we see in the approaches by the schemes? Firstly, a request for a meeting on coding. It will be issued usually by the forensic division, which immediately creates great concern. Because if somebody sends you a letter that you are subject to a forensic investigation, immediately the question is, for what? What did I do wrong? Where's the proof? Give me the statements of account. None of those are provided in most of these requests for meetings. During the meetings, if the medical practitioner goes on his own, he is, of course, outnumbered. There are 3 to 4 people from the schemes who usually attend the meetings. And the aggressive behavior and the demands made are rapid and quite aggressive. The moment that the practitioner has a lawyer present, it gets, in most cases, even worse. It is an immediate downright fight without proof on the table. A very disturbing tactic is to demand clinical notes from the practitioners. Now, a practitioner has, of course, a duty to keep the information of his patients confidential, even more so in terms of the new Protection of Personal Information Act, or POPI Act, and may not disclose personal information without the patient's consent. The medical aids will argue that the patient, being their member, has authorized them to access their patient's personal information. That may be the case, but in all of the contracts that the medical aids have with their members, a patient has a right to withhold or withdraw that consent. And it is not for me, the place of the practitioner, to provide that information to the medical scheme upon the scheme's demand without first approaching the patient and requesting the patient's updated consent for that specific action that is required by the scheme. It has to be a current, informed consent by the patient that it approves the practitioner to disclose information to the scheme and also which type of information. And the schemes challenge this. They insist on clinical notes, which they then very often misinterpret or use against the practitioner. So in view of the POPI Act, I may advise all of the practitioners, do not disclose any information of your patients unless you have updated, current, written consent of that patient. If the scheme has a problem with that, the medical scheme can ask the patient for the consent and provide it to you. It is, however, not your place to provide those details to the scheme. Practitioners are also threatened from being scrapped from the role, losing the accreditation of the Health Professions Council if some of these payments aren't made to the schemes. That can only be if there is theft, fraud, negligence, or malpractice. The scheme cannot, by demand only, ask the HP, Health Professions Council of South Africa, to actually disbar or deregister a medical practitioner. Okay. Then, of course, acknowledgements of debt are being presented to the practitioner in view of a kind of a complacent position to say, we will let you go, we will leave you if you will just pay us X amount, and once we have an signed acknowledgement of debt, we won't bother you again. Now, for me, it was interesting that if a scheme demands an amount of 2.5 million rands from a practitioner who they allege improperly coded or claimed, and then in order to induce the signature of an acknowledgement of debt, the scheme agrees that it's fine, they'll give a 50% discount. I query the bona fides of the scheme. Either the money is outstanding and you need to get it back, or it's not. But negotiating discounts with practitioners, and very often off the cuff, large arbitrary discounts, in some way for me taints the entire process. There is no engagement with the patients. This is another great concerning point for me, is that usually these clawbacks happen without a single patient being aware of the fact that his practitioner is being clawed back for amounts that appear to be due according to the scheme. The patients are not informed of the fact that their claim, their treatment has become the focus of a clawback. And then the last most concerning point, that the funds that are being clawed back do not reflect in the savings accounts or the benefits of the patients whose treatment is now being called into question. So the clawed back amounts fall into the general reserves of the schemes. And that, of course, again, brings the whole bona fide into dispute. Why would a scheme not then reimburse the patient from whose benefits the initial payment was made that was now undue? Why would that money not go back to that individual patient? Where does it go and what is it being used for? The medical schemes confirm that they use it for the greater fund, meaning they have greater liquidity. Now, the liquidity of the firm of the scheme is not the practitioner's responsibility. Clearly, there must be a reclaim on behalf of a patient, a return of the funds to the patient. It cannot be that these schemes take the clawback funding and use it for other purposes. to strengthen their bottom line towards their shareholders, for example. Right, current litigation pending, before I run out of time or run over my time. The South African Physiotherapy Society have created a separate company, and they have now instituted an application in the Gauteng North High Court. They have instituted their claim against the Minister of Health, the Council for Medical Schemes, by name Discovery Health, and then 79 other medical schemes and funds. In order to do so, they have released funds, and this application is going ahead. Then we have a second large group of concerned practitioners. They formed an association, not a company, called themselves the Association of Concerned Practitioners, and they will be instituting their claim quite soon. They will be asking to suspend all clawbacks until the Act has been properly interpreted. That is also what the SASP application has asked the court to do. And then a revision of the application of the interpretation of Section 59 in both of these court applications. The second application to be brought by the Association of Concerned Practitioners is also going to address the constitutionality of Section 59.3 and the way in which it impacts on a variety of rights. Firstly, just administrative action. That means due process. I've put some general wording in brackets. The right to equality. I want to stop there briefly because often practitioners say that I'm aware of other practitioners who do exactly what I do. However, they are not being clawed back. Why? Why do we not all get clawed back if we use the same coding? Then the POPI Act, as I mentioned, the Protection of Personal Information Act, the fact that there are demands on the release of statements of account, release of clinical notes, personal notes, etc. The freedom of profession. This is an important right for medical practitioners. You have a freedom of profession to decide which procedures must be performed and which not. You are a trained professional, highly specialized. It cannot be that an administrative officer in the office of a scheme can decide what they think you should or should not have done. That is a decision to be taken by a peer review board. That is a decision that one could evaluate according to clear guidelines and rules, obviously. But it is not within the power of a scheme to question or query your discretion, your professional discretion on how you're treating your patients, unless it is theft, fraud, negligence, or malpractice. We keep coming back to that. Then the limitation of rights, the fact that the Medical Schemes Act limits constitutional rights, brings it under the umbrella of Section 36 of the Constitution that says that fundamental rights may only be limited by other legislation, providing that it complies with quite a long list of criteria. And then finally, human dignity. The fact that many medical practitioners are being accused of theft and fraud, whereas they might have quite innocently believed what they are doing is correct, never had the opportunity to query or to amend their statements of account within the set number of days, and being accused of criminal behavior in meetings, in letters, in emails, is actually very traumatic. In the disclosures that we have of all of the medical practitioners who have come forward to these attorney firms who form part of these groups, there has been a great relief to find out that they are not alone. Many practitioners think they are the only ones who are being targeted. So often has a person said to me, I didn't tell anybody because I thought I was the one who was the criminal. And once they start sharing, it becomes quite clear the incredible extent of trauma that we are seeing there. The way forward, what we suggested, and if I use the word we, I'm talking of a collective of lawyers who have been engaged in this, and then opinions that have been requested from the academics such as myself and Professor Gravett and also others on our viewpoints on interpretation of legislation and the management of the processes and administrative law, of course. The practitioners must join their professional bodies. There are many, various ones. South African Private Practitioners Forum, for example, the Dental Association, I know are also showing some activity to try and get their members to open up and to share with them clawback experiences. These bodies must now start putting their money where their mouths are, or put their money where everybody else's is. Approach the CMS and put pressure on the CMS to issue their final report on what they think Section 59.3 should mean and how it should be interpreted. And then the Health Professions Council, of course, should also intervene. It is not necessarily a council that has direct jurisdiction on the funding issues and the payment issues. However, it has its own opinion in this matter. It has confirmed that it supports the position that theft and fraud must be proven in a criminal court, and negligence and misconduct basically by a regulatory body. And this was in 2017. So already then there was support for this. Then to support an amendment of the Act that set off may take place. That red arrow of my slide earlier on indicates why we need legislation to enable schemes to recoup money that was unduly paid. But there must be a due process. There must be engagement with the practitioner and then an independent hearing or review. The actions in the courts aren't class actions. This is my last point. A class action would mean that we need to have a class certified, and that takes 2 to 3 years. And thereafter, you have to make sure that all the members of that class action comply to exactly the same standards and qualities. And that is a bit more difficult in all of the medical professions that we have, the biotechnicians, the dentists, the biokineticists. They're also being incredibly harshly clawed back from at the moment. So group actions, and then to reclaim whichever amounts have been clawed back that were not due to be claimed by a medical scheme from a practitioner. And that is the way forward that over some 18 months, we have now tried to figure out will be the best route to follow. Thank you.
Thank you so much, Prof. That was very, very thought-provoking, and I think going forward, this is going to assist and help us quite a lot. So, yeah, without ado, I'm going to introduce our next speaker. Our next speaker is Prof. Willem Gravett, who is an associate professor in the Department of Procedural Law at the University of Pretoria. He teaches law of evidence, civil procedure, legal practice, and trial advocacy. Before returning to academia in 2013, Willem was in a private law practice in New York. He is also the author of The Fundamental Principles of Effective Trial Advocacy and numerous journal articles on trial advocacy and litigation techniques. He's also a member of the International Association of Procedural Lawyers. Willem is admitted as an advocate of the High Court of South Africa and as a member of the New York State Bar. With this short introduction, I now hand over to Prof. Gravett for his presentation. Yeah, we're looking forward. Thank you.
Thank you, Dr. Kutsia. I actually don't have a separate presentation. I just participated in Professor Kushka's presentation, but thank you very much.
Can I then ask Dr. Oosthuizen to come in? And I think Dr. Oosthuizen is going to take some of the questions, and I think we can have a discussion around what was said, because it's extremely important. And this is something that affects nearly all of us as medical practitioners, whether you have been received any of these notices from the medical schemes or not, you at least know of someone who got it. And yeah, so William, over to you.
Thanks so much, Dr. Kutsia, and thank you very much to Professor Kushka and to Prof. Gravett as well. I think it's important, as Prof. Kushka has said, that this issue comes into the light, that we talk about this and that we together discuss what it is that we're going to do about this. We've been given some clear suggestions as to what it is we should be looking at. And I know that SAMA has engaged thoroughly with the Council on Medical Schemes. We've been in discussions with the Health Professions Council, and we've assisted various members in their independent capacities in dealing with the schemes, in many cases trying to stop them from signing these terrible AODs, and having firsthand experience of some of the awful tactics that get used when one enters those boardrooms with the medical schemes. There are some questions in the chat. I'll direct these to Prof. Kushka and to Prof. Gravett. We've got a question here from Dr. Muhammad, or Rihaz Muhammad, saying, is there any way to litigate against the scheme who bullied me into paying a clawback in 2014 and retrieve money paid to them? I don't know, Prof. Kushka, is that something you would want to answer perhaps?
Yes, thank you for that question. This is exactly what the Association of Concerned Practitioners is aiming to do, is to reclaim all the amounts that were paid where an acknowledgement of debt was signed under duress. Where a claim is proven to have been fraudulent, or money was stolen, there was negligence or malpractice, then clearly that money that was paid back to the fund cannot be recouped or claimed back. However, if it was where the practitioner signed an acknowledgement of debt under duress, I think what is important is that your claim against the scheme also prescribes. So you have to understand there's also a 3-year time limit. However, it starts when you are aware of a claim that you have, or should reasonably have been aware of it. And in some cases, we found that the acknowledgements of debts signed by the practitioners, they signed thinking they were doing the right thing, and that they only now are finding out that they should not have signed. They were never supposed to agree to repay amounts of money to schemes. And for that reason, Professor Gravett, if you could weigh in here, I think prescription for your claim against the fund would not be from date when you signed the acknowledgement of debt, but from date of when you realized you shouldn't have done so.
Yes, I completely agree. And also, because there is so much uncertainty about the interpretation of Section 59.3, I think the schemes would be hard-pressed to claim that you should have been aware of your right to claim back the amounts you paid to them before now that the other practitioners are in fact taking action. So I think at the earliest, your term of prescription would start around now, the 3-year time period.
Yes.
I see there's a hand raised from Dr. Kutsia. Dr. Kutsia, if you'd like to come in.
Thank you so much. I just would like to know and understand why medical schemes asking you to sign the debt of acknowledgement of debt, and then giving you a sort of a discount, as what we all know. Isn't that cohesion? Doesn't it mean that they are actually also part of the so-called crime that they are accusing you of, because they want to claim back the money, and then they say, please sign and I'll give you a 50% discount, or I'll give you a bit of, some incentive to sign this. Surely that's also not correct. That's my one point. And the other point is, a lot of our, especially the general practitioners, are forced into managed healthcare contracts, because if you don't sign those contracts, your colleagues around you will get the patients, and the patients will be telling to go to Dr. X, who's part of the network. So use very nice words. Network consultation, more benefit if you go to Dr. X. But if you really go and look at it, it's not really, maybe 2 more consultations with Dr. X. And but for that, you sign your life away. You sign, and then once if they start to sort of investigate you, they say, but you have agreed to abide by our laws and our rules. So that is the way that managed healthcare contracts are currently conducted, is also a huge problem. Thank you.
Yes, I can just briefly say, sorry, Professor Pat, I just want to very briefly mention something I forgot. And this is the strategy that many practitioners have now started to implement to prevent them from being clawed back, to get some income at least into their pockets, is to run cash practices. And this is to the detriment of obviously the patients who cannot afford healthcare on that basis. But the practitioners are very dependent on the stable of medical schemes, where there are many subsidiaries coming from one large medical scheme. And therefore, they just cannot work in any other way other than to charge cash. And in the event of issuing a receipt to the patient to allow the patient to claim back from his medical fund, the medical scheme has outright told the patients the practitioner is being paid twice. They paid the practitioner, and the patient paid the practitioner. Therefore, there's theft, and the patient must claim the money back. The practitioner, claiming clawback, then says to the patient, I didn't get anything from the fund. I charged you, and I gave you a receipt, and you must claim from the fund. And the patient, of course, not managing to reclaim from his fund, then leaves the practice and does not continue to that specific practice. So the whole scenario is creating many complications. Regarding the contracts, yes, that is something I interrupted, I think, Professor Gravett, or was it Dr. Oosthuizen? Apologies.
No problem. Please continue.
Yeah. So the contracting in, or the practices are there to manage, obviously, the relationships between scheme and practitioner directly. Many of the provisions in the older contracts are extremely onerous on the practitioners, and they can be challenged on the same basis of constitutionality, the factors that we briefly alluded to. This is also part of the Association of Concerned Practitioners drive. They have some practitioners who have contracts with medical schemes, and they are also joining them in their court application. So it is not just practitioners who have no contracts with the schemes, but also those who do, who are going to be all together in this one application, dealt with regarding the limitations that are placed on practitioners. The reason for an acknowledgement of debt, Professor Gravett, if you can just address that quickly. Why do they push so hard for acknowledgements of debts?
Well, they push hard for the acknowledgement of debt because then contractually, at least, the scheme believes that the medical practitioner is then liable for the amount. But a contract entered into under duress is open to attack. And although I don't think that the conduct of the medical schemes in this regard are necessarily criminal, they are definitely, the actions are immoral and unethical, and may very well be illegal because it violates every principle of just administrative action.
Yeah, no, it's just terrible. Here's another question in the chat, and this is going to segue nicely into the way forward, I suppose. There seems to be no avenue for recourse should we have a complaint against a scheme, whether it be a small complaint, a bigger issue. I do not feel there is anyone I can complain to. A colleague tried to complain with the Council of Medical Schemes, and the DSP contract was suspended by the scheme. I think this brings us to what is the way forward here, and that's part of the reason why I wanted you to address the attendees tonight. So we are aware that there are some of these group actions being implemented, and it seems to me that, judging by the attendance of this meeting, that there is a large component of SAMA doctors and other medical professionals that perhaps weren't aware of these group actions and perhaps would want to join. And I know that SAMA would also want to put its full weight behind its members in some of these actions to ensure that they receive the justice that they require. Can we perhaps have some details about what are the options going forward? And I'm sure I speak for many on this call who would want to know more information about this planned action, and where can they perhaps get some of this information? And is that something that could be shared with us to then share with them? I know that from SAMA's side, we have spoken about this, but I would love to share some of this information with the attendees on the call.
Thank you, Dr. Westhuizen. Yes, the Association of Concerned Practitioners has a letter that contains all the information of the processes that they are following. And then they also have the forms that one can complete to become a member of the association. Of course, the entire problem hinges on funding and the fact that the more we join in a single action, the cheaper it is at the end of the day. I think the most important point that came out is to prevent duplication. We have, for example, a practitioner in Cape Town. His lawyer issued summons in 5 different courts in the country because he didn't know where to go, where the jurisdiction was. And it is a lone voice in the wilderness, and it costs him a lot of money at present. The case has not yet been heard. There are here and there spotty claims being brought in the different courts in our country. However, the best is if everybody concerned who feels that they have been victimized, they are in this position where they need legal assistance, joins the association. It's not about the money. It's also about the victimization, that if you are being victimized at a later stage and your name is part of the list of applicants or of the association, then there is a direct link between your involvement or engagement in standing up and tackling this issue and the subsequent victimization that you might experience. The South African Physiotherapy Society was very close-fisted in their approach. For a while, many of the other associations and societies were asking what were they planning, what were they doing, because there were these little bits and bobs coming out. We're going to do something. We're going to do something. At the end of the day, without disclosing to any of the other, what can I say, the other professions, I don't want to call it the other professions, branches, the other branches of the professions, what they were going to do, they brought the court application. I must say I was quite surprised that they went so far as to cite all of the schemes in the country, every single medical aid fund scheme, and then also the Minister of Health, which I suppose was a safe bet. But they are now running with that case on their own. And I don't think it would be wise to now try and join that action. Cost-wise, I think you might be in a bit of a risky situation for all of the costs of the respondents if you do not play it very, very straight and narrow. All of these attorneys, groups, association, and then the specific SASP are advised by quite senior advocates, very well-known and experienced senior advocates in administrative law and administrative justice. So the fact that the matters are now being taken forward does not mean that it's reckless per se. I'm not saying that the SASP is acting recklessly. I'm just thinking out loud that it would have been great if a larger group would have been prepared to join forces. But they have chosen not to do so, which leaves all of the other branches of the profession to decide whether they actually want to get involved in a singular action or take individual action. And my legal gut feel, and you will excuse me if one is older than 55, one's allowed to say that, I suppose, is there's strength in numbers. There's strength in numbers, and having these spurts and bursts here and there, I don't think is necessarily as effective and as cost effective as it would be. There are many, as I said, biotechnicians and the biokineticists and those branches who are all suffering as well. And I think maybe joining forces as much as possible. I will send the Association of Concerned Practitioners documents through to Dr. Westhuizen, who can then distribute it to the members of SAMA. If you have been clawed back and you would like to discuss the merits of your case on something, you're more than welcome to contact me and I can redirect you. I am doing all of this at this moment in time without billing anybody. So I'm the wailing wall if you want to come and talk to me. But it's about finding guidance in where you would like your case to go. And I think that you must discuss with SAMA. As individual members of SAMA, I trust them for a high quality opinion and assistance. Use your membership with SAMA to give you the right guidance in this situation. We'll provide all the details for you.
No, thanks so much for that, Prof. Kushka. There's a hand. Oh, sorry, Prof. Gravett, please come in.
Sorry, I just also want to add that if you are a practitioner who is now faced with a clawback or who has received one of these mysterious, threatening emails from a medical schemes forensic department, before you go it alone, please also reach out to either me or Professor Kushka so that we can advise you on how to conduct yourself before you go in, be bullied, and then sign one of these acknowledgements of debt.
Yeah, that's a very good point. Thanks so much.
Yeah. Can I just one point, sorry, on the representation. You do not have to have legal representation in the meetings. That is not required, and neither are we pushing for that either. Just a word of caution. There are some medical consultants who are assisting practitioners. However, they are not attorneys. And in not being attorneys, there are some malpractices that will also be reported to the Financial Services Conduct Authority, because there are some medical advisors or some firms who are advising practitioners incorrectly about steps to take and how to deal with these meetings. So be very careful for medical consultants who are not lawyers for legal assistance. That's not why they are there. They might be able to advise you, but please take great care. There are two of the larger groups that are, as I said, being reported as we speak to the Health Professions Council for colluding with the schemes and not offering medical practitioners objective advice and proper legal assistance.
And thanks so
So
much,
that's
Prof.
just
Kushka. And just to emphasize to all the SOLMA members on the call, if you do receive such an email, we do urge you to reach out to us at the legal department as well, to the private practice department, so that we can also help guide you through all of this and ensure that you don't sign any of these AODs. Unfortunately, we've had a couple of cases where practitioners come to us too late after they have signed, and just leading to a world of problems. Dr. Mzukwa, please come in, and then after that, Dr. Kutsia.
Thank you so much, William, for this opportunity, and thanks to our presenters for this informative session. There is a question there, or there's a comment, if I may put it so, by Dr. Hyatt, if I'm pronouncing it well, who feels or believes that when she made a submission to SAMA in 2018, her submission was ignored. And I just want to, first of all, apologize on behalf of the association. I do not have the merits of that case, but I think that SAMA has been involved since then when this Section 59 issue emerged. SAMA has been working with other doctor groupings, to fight on behalf of practitioners, and even made presentations, in the panel that was erected by the Council for Medical Schemes. But I would urge her to truly resubmit that to either Dr. Rosanna, who's here in this platform, or else Dr. William Oosthuizen, who is taking the session on questions and answers, our legal department, to resubmit that complaint to those two colleagues. Thank you so much. Just wanted clarity to give attention to that question or comment.
No, thanks so much, Dr. Mzukwa. Yeah, and certainly, and I'm terribly sorry to hear that the matter didn't receive the attention that it was supposed to receive. And I promise you that myself and the colleagues on this call will certainly rectify that. There's nothing worse than being left in the lurch when one is faced with a matter such as this. Dr. Kutsia, please come in.
Thank you so much. I just would like to ask any of the two profs that once if you are being called to these meetings and you try to defend, there will normally be the clinical panel sitting there. And I had quite some time ago had to help a colleague of mine. And one of the things that I said to the clinical panel that was sitting there is, are you all registered by the HPCSA? And it turned out that they're not. Only one of the persons there were registered by the HPCSA. And I then made a comment and said that, well, in that case, you cannot peer review this doctor. As you are a nurse, you're not registered. And they were quite upset with me, but I stick to my guns because it is wrong. You cannot expect a nurse to give comment as part of a clinical peer review from a medical scheme on another, it's not even a GP, it is a person who's been specialized. How can you do that? And in the end, we settled that argument, and because I just refused to work with the nurse. Well, can you comment on that? Thanks.
Oh, sorry, Prof. Kushka, you seem to be on mute.
Thank you. Yes, Dr. Kutsia. Yes, that is that was the issue with the physiotherapists as well, is that a chiropractor who was not even registered to practice in South Africa was the single person on that clinical panel, fully employed and fully salaried at Discovery Health. And she would then evaluate and take the decisions on the suitability of therapies that these physiotherapists had performed and the coding in accordance thereof. We have so many different problems regarding the constitution of the clinical panels that are being driven by employees of funds that clearly are not impartial. They are not highly specialized and they are not impartial. I can give you a very brief example of a biotechnician, a cardio biotechnician who had pre-authorized claims from the last 3 years clawed back. The fund is actually claiming back every single cent that he earned the last 3 years, because the scheme is of the opinion, and these are all pre-authorized, that this guy who keeps you alive while you are under anesthesia during a heart operation, that his the hospital charges for the operation, the fact that he's expressly contracted for his specific speciality by the surgeons and the hospital, and pre-authorized, that his job could have been done by the nursing staff, and hence he has to pay everything back. And he says he's been found obsolete. His entire position has been found to be obsolete by a medical scheme who has not investigated anything, what he did, how he did it. There are no allegations of what he did wrong or not. And this is the concerning part, is these are here and there spotty reports of absolute self-help overreaching to the point that you can't believe what is actually happening. And that is why in the meetings, it is not always the later meeting where you have a clinical panel that sits in. The initial meetings are held by a team of the forensic divisions. And it is quite, as I said, acrimonious. The conduct is quite aggressive. I asked in my scenario whether I can record the meeting. I was told that it would be possible by the facilitator. When I came home, the recording was compromised, and it was not on my side. It was compromised on the other side. However, you know what they say about an old fox. I never record only by one device. I always have another one, my cell phone. And that, having been transcribed, is now the part of proceedings of allegations made against the practitioners in this case, that they were told they were thieves and they were defrauding the funds. Without an actual recording of the meeting, we could not have continued process. So even though you do everything right, you might be in a position of extreme duress and be unable to understand the evidence value, what one needs for evidentiary value, how far allegations are allowed to go or not go, what you are entitled to ask for or not to ask for. So I think step one is contact SAMA as soon as possible. Do not go into a meeting, do not respond. There are, of course, deadlines. If we do not hear from you within 7 days, we will start clawing back. No, that is legally untenable. You can't force someone to become liable towards you if they don't respond within a set number of days. And this is what's happening in some of these situations. So in all their defense, I should say the SASP, I think, got so caught up in trying to figure out which fund did what and which scheme had which type of modus operandi, that they decided just to sue them all at the same time. So maybe that explains why this is happening. But I want you to really understand that just your cousin who's studying law or whatever is not the person to assist you. The person to assist you is somebody who knows how the Section 59.3 clawbacks work, and to be with you in the meeting and advise you. And we're not looking for work. Please believe me. Professor Gravett and I are busy enough as we are. But please contact SAMA and do not sign anything until you have had some professional input on that.
Yes, and just to Professor Coetzee point, and Professor Kushka also touched on this, regarding the composition of the clinical panels, I don't care, from my perspective, I don't care if it is highly qualified specialists on these panels. If they are employed by the medical scheme or if they have any association with the medical scheme, they are by definition not impartial and is in no position to make any findings on the clinical practice of another medical practitioner.
Yeah, being cognizant of time, colleagues, two quick questions, and then we should try to close the meeting. This is, of course, a topic one can go on at length on. Here's one. So the question is about the process that gets dragged out, and with the prejudice that brings, of course, and then there is another question regarding the managed care contracts or the designated service provider contracts that specialists and other practitioners enter into. Should these be relooked in light of some of the practices that we have seen and some of the malpractices that we have seen?
Well, yes, I think in the first question on the dragging out of the process, it is inevitable to get to a point of certainty or clarity that the process will take longer than shorter. My physiotherapist got very, very frustrated. Of course, it took a great toll, emotional toll, also on the ability to work. They told me it's very difficult because you start second guessing yourself with every treatment, because what if I'm doing this incorrectly? What if I am not going to get paid for this or that or the other? So that is something that sadly is part of the process until we have clarity in the courts and we have a decent set of rules, regulations, or whatever we decide to amplify Section 59.3's application with. The process is a bit slow and the wheels do grind slowly, but it will carry or pick up speed now and will carry more and more weight because of the different processes that are now being launched. So I think the urgency, the sense of urgency is there. Just to inform the practitioners that there was a Section 59.3 investigation that Dr. Oosthuizen referred to, and that the interim report has been published. And we've been promised the final report, but the Council of Medical Schemes has not been forthcoming with it because, frankly speaking, I don't know whether they know what to do. I don't know whether they are able to provide a set of rules or guidelines that will be binding per se, without possibly more engagement with the legislator. But the time that passes is very onerous on your health and your practice, and just get back to SAMA as soon as possible for your support from that side and for the legal division to inform you of the various steps and why things are taking a bit longer than they should take. So there are some delays. We can do nothing about that. Then regarding those healthcare contracts, that is part of the Association of Concerned Practitioners litigation strategy, is to also have those contracts evaluated again, and actually to make sure that these contracts do not infringe on the rights of freedom to trade and are not more onerous on the healthcare practitioners than they should be about the right of a fund to withhold monies from a practitioner, the right to set off of debts without meeting very specific, strict criteria of burdens of proof. That will carry through into those contracts as well. And that I'm quite sure of, that whatever is being decided or will be decided on Section 59.3 will have to carry through into those contracts. You cannot just allow self-help as a broadly worded provision in a contract. there will have to be more clear guidelines as to when a set-off may in fact happen.
Thanks so much for that advice, Prof. Kushka. And to all the members on this call, we will be sending out information shortly, and to the membership in general, those that have been affected. It's about time that I think as many of us stand together. Just seeing the attendance here tells me that many more practitioners than perhaps we could have realized are affected by what we've discussed tonight. And we're hoping to really make an impact here and rectify the current untenable situation. With that being said, I would just like to thank Prof. Kushka and Prof. Gravett for taking out the time tonight and basically informing us and arming us with some knowledge around some of these processes, just assuring some of the practitioners on this call as well that what they are being subjected to is irregular, that you aren't guilty without a trial just because a medical scheme says that you are. So thank you very much for that. I think there is already some comfort in just knowing that. We will send out email addresses of where we can be reached, and we'll also circulate some information around the Association for Concerned Practitioners and how SAMA and its members can become involved. And with that, let me hand it over to Dr. Mzukwa just to do the final close off. Thanks so much, everyone.
Thank you so much, William, for that session. Before I close this gathering or the session, I would like to remind all the attendees of this meeting that after the meeting, just after my closure, there will be a survey that will open automatically. So just just take a few minutes to answer just about 5 questions that will come out just immediately when I finish. But really, thank you, William, for that session on questions and answers. Firstly, I would again also thank Dr. Kutsie, the chairperson of SAMA, for her introduction. And I would also like to thank everyone who worked, to make this event possible, and for everyone who attended this gathering. Prof. Kushki and Prof. Gravett, thank you very much for your presentation. This is an extremely important issue, and something would all be well informed on your presentations tonight have really been insightful and have provided us with clarity on many matters. Your involvement tonight is highly valued. Thank you once again. With those short remarks, I would formally close these proceedings. Thank you all again for attending. Until next time, have a good night and goodbye. Then can we have our display of the survey? Thank you.